amendment to the council. This is the attorney. The jump sorry.
Good morning, Taylor Gang. Good morning, y'all. Good morning. Y'all know we are on day 16 of the YNW Melly trial, y'all. We at the end. So, let me see what's really going on. All right, y'all ready to get it started? Y'all ready to get cracked? Good morning, Fancy, Patricia, Beta, and Jen. Check y'all out. My people are here. My people are here. All right, so I just jump right into it. Y'all know we are on day 16. Y'all, the state has rested. Malik, I gotta figure out. Hey, good morning, Hershey. I gotta figure out I gotta find a link to the hearing that we said we were gonna listen to. So I think today I have to end a little bit early. My son has a doctor's appointment, so we'll be ending around 1 Central. So that's 2 Eastern. And after we finish this up, because I think it's gonna go pretty quick, I'm thinking that we could either watch the documentary, or we can jump into the hearings that have happened for the upcoming trial, including the hearing where the prosecutor gets removed from the case. So I'm gonna be looking for that as we kind of go through this last day. Here closing arguments, all that good stuff. But if we don't get to it, we'll just pick back up on Monday doing, a refresher on everything that's happened for the upcoming trial. Maybe even hear about some of the evidence that is going to be thrown out, etc. I'm also going to start looking for some of the motions that have already been filed for the next trial. So we can be abreast, y'all. We need to be up to date. And we need to know everything. So I spent some time thinking about it. I think that's how we're going to spend our time, at least for the earlier part of next week. And then we will find us something else to watch if another trial has not started. Honestly, I do think that something else is going to start up next week. We could probably watch that to kill a little time until we get to our more anticipated or highly anticipated trials that we want to watch. So I will, without further ado, I will just get us started, y'all. And be quiet.
Hold on, it's my fault. We're ready to start now. So we broke yesterday, state arrested their case. Now we're calling.
Yes, sir. We're going to call Adrian Davis.
Adrian Davis, please. Mr. Davis? Are you Mr. Davis? Oh, yes, welcome. Come on up here. This is our witness stand. When you get there, just remain standing for a bit. Raise your right hand to be sworn.
Do you solemnly swear or affirm that testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth? You spell the first and last name of the court.
ADRIANTHAS.
Please have a seat. Davis, microphone in front of you will adjust up or down, but does not move back and forth. Okay, ready to go? Good. Counsel, you may proceed.
How old?
24.
Have you ever been convicted of a crime?
No.
Thank you. I need to know an answer from side order.
Do you have a nickname?
Yes.
What is it?
AD.
Okay. First of all, take your hand away from your mouth because you still have it here. Okay. And I need you to speak into the mouth. Do you know someone by the name of Anthony Williams?
Yes.
You know what his nickname is?
Seth.
Do you know someone by the name of Christopher Thomas?
Yes.
Do you know what his name is?
Julie.
Do Do you know a person by the name of Cortland Henry?
Yes.
And do you know his name?
Yes.
What is it? Do you know, D-O-R-T. You know, Jamel,
Yes.
you see him in the courtroom today?
Yes.
You're pointing out for, is that man right there?
Yes.
You know my another name?
Melly.
Do you know someone by the name of Trevon West?
Yes.
Do you know his name?
Fed.
Do you know someone by the name of Toby Mills? Do you know his name?
Cope.
How about, do you know someone by the name of Dontavius Withers?
Yes.
Do you know his name?
Tate.
Let's start off with the first individual name, Anthony Williams, also known as Seth. How did you meet him?
9th grade school.
How about Christopher Thomas? How did you meet him?
During school.
Portland.
In elementary.
How about Mel?
6th grade.
Trevon West.
During school, 9th to 10th grade.
And his nickname was
Fed.
Toby Mills.
Since elementary.
And finally, Dontavius Withers.
Down.
So you went to school with Williams, Thomas, Henry, Melly, Glass, etc.
Yes, sir.
Everybody's talking. At any time during school, did any of you have any problems with each other?
No, not at all.
Would you label yourself good friends, associates, close friends, or what?
Good friends, close friends, best friends.
Now, did Melly also have another name besides Melly and Jamel?
Yeah. What's up? We only call them that those crazy legs.
Crazy Legs.
Yeah.
And why was he called Crazy Legs?
Because he liked to dance.
And that's why you got that nickname.
Yeah.
Was Melly a big size kid when you guys were in school?
He's small.
Did there come a time that Melly, I'm referring to this young man, Jamel,
Yeah.
come a time that Melly got involved in the music industry,
Yes.
specifically music?
Yeah. Back
Now, still in that area?
My granddad owns properties, rental properties and stuff, real estate. So we just cut grass, paint, whatever we need to do, keep the properties up.
I want to draw your attention to the year of 2018. Did there come a time that you came down to Broward County, Miramar, Florida?
Yes.
About when was that?
I don't remember exactly, but I want to say probably like September, July, something.
Okay. And where did you stay?
At Jamel's house.
Who else was living at Jamel's house when you came down in August or September of 2018?
Me, Jacoby, Melly, Sat, Juvie,
Juvie was Christopher Thomas.
yes, Tay, and Cortland.
And was Melly in the rap music business at that time?
Yes, I believe so. Yeah.
Did you all get along together?
Yes.
Were there ever any arguments, fights amongst you guys?
No.
And is that where you met Dontavius Withers?
Yes.
And does he have a nickname?
Tay.
Who was paying the bills at the house?
I don't know, but I'm pretty sure Melly was.
Let's go to the day of October 25th. And so you have an idea where I am. This incident that we're here on occurred in the early morning hours of October 26th. Okay? And I'm referring to the shootings of Anthony Williams and Christopher Thomas. On October 25th, the morning of, and during the day, what were you doing?
Just chilling at the house, hanging, smoking and drinking.
Who were you smoking and drinking with?
Jacoby, Teddy, everybody who usually be at the house.
Okay. Williams?
Yeah.
Thomas?
Yes,
Portland Henry?
yes,
Trevon Glass?
yes,
Dontavius Withers?
yes.
And were there plans to go to a recording studio that evening?
Yes,
Did you in fact go to the recording studio?
yes,
And that was after you all were, for lack of a better term, smoking dope, weed,
yeah.
correct? And having a few drinks?
Yeah.
What was the drink of choice, out of curiosity?
Hennessy.
Hennessy.
Yeah.
Who all went to the studio?
Me, Jacoby, Melly, Sack, Julie, Cortland, Trayvon, and Tate.
Did you all go in the same car?
No,
Going to the studio, approximately what time did you get there?
I don't remember.
Was it during the day or at night?
At night.
Did you go in the same car or were there two
We
cars?
took 2 cars,
What type of cars were they?
a Jeep and a Mitsubishi,
What color was the Mitsubishi?
red.
Will you tell this jury who got into the red Mitsubishi to go to the studio?
Me, Jacoby, Tate, and Fetty, Trayvon.
And who got into the Jeep to go to the studio?
Melly, Sack, Julie, and Boyd.
Who drove, do you know who drove the Mitsubishi to the studio?
Tate,
That would be Dontavius Withers?
yeah.
Do you know who drove the Jeep to the studio?
I think Boyd did.
Okay, that would be
Cortland, yeah.
And what was the purpose of going to the studio?
To make music.
Did anyone fall asleep at the studio?
Yes.
Who?
We all did.
That was from the day of smoking weed and having a few drinks.
Yeah.
Did any arguments occur between any of you at the studio?
Not at all.
Did there come a time that you all left the studio?
Yes.
Did you leave the studio earlier than what was scheduled?
Yeah, I believe so. So we all in there sleep.
Will you tell the jury who got into the red Mitsubishi?
Me, Jacoby, Trayvon, and Tate, Dontavius.
You know who got into the Jeep?
Cortland, Jamel, Sack, and Julie.
Where were you going? Did anyone fall asleep in your car?
Yeah, we about all did except for the driver.
Did there come a time that you were woken up before you got to the house?
Yes.
What happened?
We pulled over and that's when Melly got in the car with us.
Do you know where you pulled over?
And I don't really remember.
Were you woken up?
Yeah,
Why?
because I was getting pushed over a little bit.
And are you 100% sure that this young man got into the red Mitsubishi?
Yes.
What happened to the Jeep?
I think they just kept going.
Where'd you go? Did he have to unlock the door?
Yes.
Do you know who has the keys to Melly's house on October 26th in the early morning hours?
Jamel and Borton, they only one who had keys to the house.
Did you have a key to the house?
No,
Did Williams have a key to the house?
no,
Did Christopher Thomas have a key to the house?
no,
Did Trevon Glass have a key to the house?
no,
Did Jacoby Mills have a key to the house?
no.
And how about Dontavius Withers? Did he have a key?
No.
Okay, so the only two people you know who had a key to the house was this young man
Yes,
and Cortland Henry.
yes.
Did you see this young man unlock the door of the house?
Yes.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon, he was in the car still asleep.
He was in the car asleep when you got to his house?
Yeah.
Did you see where Melly went?
To his room.
And where was his bedroom?
When you first walked in the house, it came missing. It's right down the left.
Okay. This is a 1 or 2 story house.
2.
Where did you go? Where did Dontavius Withers go? I'll bring it up.
Thank you.
Do you know where Dontavius Withers went?
To his room upstairs.
Do you know where Trevon Glass went?
To the room upstairs.
Do you know where Jacoby Mills went?
He slept on me.
So the 4 of you went upstairs, correct? And this young man went into his bedroom.
Yes.
How many people went upstairs to go to sleep?
30.
And you?
Yeah.
That would be,
Me, Jacoby, Melly. Well, no, Melly was downstairs in his room. Me, Jacoby, Fetty, and Tay. So 4 of us.
okay. And Melly went to his bedroom?
Yes.
Did there come a time in the early morning hours that you were woken up and heard some distressing news?
Yes.
What did you hear?
That second Julie was shot.
When you heard that, did you see Melly in the house?
Yes.
Did you see Melly how he was dressed in the house?
Yes.
What was he wearing?
Shorts and a t-shirt.
Upon hearing that Zach and Juvie, and I really should use the correct names, Anthony Williams and Christopher Thomas were shot. What did you guys do?
We were already dressed and stuff, so we just left with Fredo's house.
Was anybody upset or crying?
Yeah, we all were crying.
Was this young man crying?
Yes.
Are you sure of that?
Positive.
And where'd you go?
Fredo's house.
That would be Fredo Bang?
Yeah.
You know where things really? Trevor Gibbons by any chance?
Yeah, I think I saw it.
Did there come a time after you got to the house of Fredo Bang that Cortland Henry showed up?
Yes.
Did Cortland Henry tell you all what happened?
Yeah, he said it was a drive-by.
When Cortland Henry arrived at Fredo Bang's house, was Melly there?
Yes.
Did you eventually leave that house?
Yes.
Approximately what time did you leave that house?
I really don't remember.
Where'd you go?
Back to Jamel's house.
Who went with you?
Me, Trayvon, Jacoby, and Fetty.
By the way, when you first learned that Anthony Williams and Christopher Thomas were shot at the house with Melly, did anyone get on the phone?
Yeah.
Did anyone have any problem locating the phone?
Yes.
Who was that?
Jamel.
You, when I backed up for a minute, you were telling the jury that you went back to Melly's house.
Mhm.
You got into yes or no?
Oh, yes.
She can't say it down. How'd you get in?
The door was unlocked.
Were you aware whether or not Melly had a contractual agreement to do a video shoot that day?
Yeah, it was something like that. I know he probably lost a lot of money if he didn't go to the music video. He was upset.
Melly crying at Frito Bank's house?
Yes,
You crying?
yes,
Because you all grew up together.
yes.
Now, did you in fact tell this what happened on October 25th and 26th to this particular prosecutor?
Yes,
Were any of us, any of the lawyers present?
Objection, relevance.
The same.
Did you tell the prosecutor, when you spoke to the prosecutor, were you under oath,
yes,
sworn to tell the truth?
yes,
Objection, Dr. Holstrom.
Sustain.
Are you 100% sure
Objection has been answered.
that Mel got into the red Mitsubishi to go home?
yes,
Are you 100% sure that this young man learned of the shooting of his friends at the exact same time you learned of it?
yes,
And that was at the house?
yes,
Are you 100% sure that when people were getting on the phone, that this young man was looking for his phone to call people?
yes.
May I have one moment, please?
Yes.
I have no further questions.
Counsel, is there any question on this?
Yes, Your Honor.
You're ready to proceed?
Okay. Mr. Gates, you said you're 100% sure that Mr. Dennis found out at the same time you did.
Yes,
No questions about that. You're sure he was at that house.
yes,
And you were upstairs?
yes, ma'am.
He was downstairs.
Yes,
But you're sure he was there. You could see him.
Mhm.
Is that yes?
yes,
And you are 100% sure his phone was missing.
yes.
Where in the statement on May 5th did you ever say that?
Objection.
Objection.
It was never asked.
Counsel, so I guess the objection is improper impeachment, so rephrase it, but I suspend the
So
objection.
you met with me on May 5th, 2022. You remember that?
Yes,
And you remember sitting down, you were present. That's yes.
yes,
Your two attorneys were present that you brought.
Mhm.
That's yes.
yes,
And I asked you questions for quite a number of hours. Do you remember that?
yes,
And do you remember being asked if you had met with anyone else with regards to this case?
yes,
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
yes. I didn't know who they were, and my lawyers told you that.
Okay.
I didn't know their names.
But you remember meeting with them?
Yeah.
Okay. And do you remember asking and being asked a question about what you talked about with them?
Yes,
Did you remember what you told them?
no,
Do you remember what you told them now?
yes.
So are you telling the jury that when you were speaking with me, you forgot?
As in, what, I'm telling them now, as of right now, yes.
So on the phone on that, do you remember if Mr. Devins had a passcode on his cell phone back then?
I don't think so.
You don't think so? And in terms of, would you be surprised to find that there was one on that cell phone?
No,
Did you know passcode?
I don't think so. I don't even remember if he had one. We all use this phone sometimes. We all use each other's phones.
So you would use his cell phone? Why?
Talk to females.
You pretend you had to get women, but you couldn't get them on your own?
Objection.
Why would you use his phone then?
Let me rule before you ask the next question, all right? It's over, go ahead, answer your question, I ask you this question.
With regards to your living situation there, you were not paying any rent, right?
Oh, no.
And nobody was paying any rent in that house except for the defendant.
Yeah.
So do you remember that evening driving to the studio?
Yes.
You remember who was in which car?
On the way there, yes.
Do you remember who was on each car on the way back?
Yes.
Okay. Are there any threats that were made to anyone that night?
No, no.
Did anyone have any other conversations or discussions? about threats from outside parties?
No, ma'am.
Is anyone worried about their safety?
No, ma'am. But Melly's a rapper. He's always gonna be a target.
I'm sorry.
I said he's a rapper, so he's always gonna be a target.
Okay. And do you remember stopping on the side of the road?
Yes.
Where did you stop?
I don't remember. It's like flashes and blinks, drinking and smoking, so I just know we stopped.
You know you stopped.
Yeah,
And do you remember if that was on a highway?
not at all.
Okay, do you remember if it was on a divided 4-lane road?
No, ma'am.
Do you remember if you guys were using GPS to get home?
No, ma'am.
And do you remember if you knew the route home?
No,
Do you remember what phone number you had back then?
no, ma'am.
You don't remember your phone number?
5 years ago, so.
Do you remember if you were awake or asleep?
Just told you. We were asleep.
You were asleep.
Yeah.
And you said you were intoxicated?
You did, Rob.
Yes.
Do you know why your car stopped?
No.
Do you have any conversations or messages with the defendant?
No, ma'am.
Do you have a phone call with the defendant?
No, ma'am.
When you stopped, was the gray Jeep in front of Redmond's Mission?
Yeah, I believe so.
Have you ever answered that question differently?
I don't think so.
If I were to show you your statement from May 5th of 2022, would that help you in answering if you'd ever said something different from what you just testified in court?
Yeah, probably.
Okay, approaching with page 33 of the statement, counsel. And you just read silently to yourself.
One line?
Lines 18 through 20.
Yeah. I basically told you. I don't know.
Okay, so now your answer is I don't remember if the Jeep was in front, but the Mitsubishi was in front.
If you watched the video, they pulled off first, so I didn't know what was in front of us.
Oh, so you watched the video.
You showed it to me.
In terms of the trial, you've been watching that online?
No, ma'am.
In terms of when you got home, you mentioned that you said Mr. Demons went to his room.
Yes.
Have you ever answered that question differently?
No.
On May 5th, 2022, remember that statement?
Mhm.
At that point, did you say, I don't know where he went, and I assume his room?
I don't know.
You don't. But you made your statement, I'll refresh your recollection on that.
Yes.
Okay, page 34, lines 12 and 13, counsel.
Yeah.
Okay, so did you previously give a different statement that you didn't know where he went and you were assuming he went to his room?
Yeah.
So with regards to the car, you're saying that you got pushed over when somebody got in the car?
Yeah.
And with regards to being pushed over, did you wake up when that happened?
Like it was flashes. Like I guess you could say I woke up.
Okay. And did they move you over or climb over you?
I don't remember.
Have you ever made a statement different than that?
I don't know. I can't remember.
Okay. Again, page 33. Question was asked: did they climb over to get you to the middle, over you to get to the middle of the backseat? Your answer was, I think I was at the window, so no. I think they might have climbed over.
Okay.
So is it your testimony that somebody climbed over you, or you pushed over,
I mean,
or that you don't remember?
yeah, I don't really remember.
You don't really remember.
Yeah.
Okay. And in terms of the phone, right? Did you see anyone get into that Jeep?
No.
You remember going to Frito Bank's house,
Yes.
and you remember seeing the defendant there. Is that a yes?
That he was there with us.
And you remember leaving there afterwards.
Yes.
You remember going back to the defendant's house.
Yes.
Okay. And you remember at that point that when we went back to the defendant's house, it was you, Travion, Glass, or Fetty,
Mhm.
and Jacoby Moss. That's it.
Yes, I believe so.
And you said that you were in and out of sleep and intoxicated.
Yes.
And in terms of you remember that Travion was the last person to get out of the car.
Mhm. Yeah, I believe so. Yes.
Do you believe so, or do you remember? Which is it?
Yes.
And you know, and you mentioned about Mr. Timmons looking for his phone, right?
Yes.
So of course he used your phone to call it and try to find it, right?
I don't remember.
You don't remember how he was trying to find his phone?
Just in the house looking for it, just like you would do if you lost yours.
So he didn't, try and find my iPhone or anything like that. Of course he used yours to do that, right?
I don't remember.
Of course, he used something like, an Apple iWatch and set it up.
Objection, there's no testimony that he had
I
it.
don't
Excuse me. One at a time. You asked the question. Objection notice. Overruled.
So of course he did all that. He went on, find my iPhone, and he's looking for it.
I don't know. I don't remember.
You don't remember. Okay. And of course he is using everybody else's phone to try and find it.
I don't know.
You don't remember. Okay. But conveniently, the phone's missing now.
Objection to the
Abstain.
floor.
Yes.
I sustain the objection.
So with regards to your conversation, you texted back and forth with the defendant prior to this event occurring, right?
Yes.
And he had sent you a picture of his driver's license from that phone number.
Yes.
So you knew Mr. Demmons, the defendant Melly, to use that cell phone 772-713-9807.
I don't know what the number says.
You have it saved in your phone, right?
Yeah, but I can't just remember that phone number like that.
And your testimony is that he's looking all over the house.
Yeah.
So in terms of the phone, did you see it again that day?
I don't remember.
And in terms of the phone traveling up to the video shoot up in Cocoa, you don't have a phone gun up there.
I don't know.
And you didn't shoot Mr. Williams or Mr. Thomas, right?
No.
But you know who we're talking about, right?
Chris and Anthony.
Yes. And in terms of the messages and things for Mr. Hammond, you're aware that his phone was broken at that time, right?
I don't know.
You don't.
Yeah, I don't know.
In terms of Mr. Demons, you know he was dating Mariah Hamilton.
Yeah.
And you know that Mr. Demons would FaceTime her on a regular basis.
Objection.
What's the objection?
There's no evidence of that.
I don't know.
Overruled.
So you know, and Mr. Demons would,
Excuse me, use the correct name.
Mr. Demons, my apologies. Mr. Demons would FaceTime and video chat frequently.
Just as bad for
And Mr. Davis, you never met with Detective Mark Money? You never gave a statement?
No, ma'am.
And so the first time that you ever said anything about the phone being missing was today, July 18, 2023.
Yes, I believe so.
Nothing further, no?
Favorite question.
Is there any regret? Go ahead.
Detective Moretti never even talked to you during this investigation, did he?
No, sir.
And the bottom line is, at the time you learned that Christopher and Anthony were shot, Zach and Juvie were shot, this man was at his house, correct?
Yes, sir.
And did you tell that to the state?
Yes.
And then were they the first ones who contacted you about this case?
Yes.
Thank you.
Is this witness excused?
Yes.
Sir, thank you very much. You may step down. You're excused. Counsel?
We would, at this time, yes.
Ladies and gentlemen, I need a few minutes with the attorneys. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research. All right, just leave no bed on the chair. Thank you. Thank you. Let the record reflect the jury stepped out, counsel remained along with the defendant. And I guess Mr. Demmons, need to talk to you, ask you a few questions, all right? You heard what your attorney said. He said he's arrested. No further witnesses. Do you hear that?
Yes.
Right now, I don't know what discussion you had with your attorneys. You got competent lawyers there. I mean, you've seen them perform here. You've discussed things with them, I assume, correct?
Yes, sir.
And you understand that you have a right to testify, and you also have a right not to testify. Do you understand that?
Yes, sir.
Do you understand that if you do testify, I'm going to instruct the jury that they have to consider your testimony as they would any other witness? Do you understand that?
Yes, sir.
And if you don't testify, I'm going to instruct the jury that you have a right not to testify, and they can't consider that, hold that against you. Do you understand that?
Yes, sir.
So my question, I guess, is did you have enough time to talk about this issue about you testifying or not testifying? Did you have enough time to discuss that with your attorneys?
Yes, sir.
Did they answer all your questions?
Yes, sir.
And what is your decision?
I will not testify.
You will not be testifying.
No, sir.
Is anyone forcing you or coercing you to make this decision?
No, sir.
Anybody make any promises or on the contrary, make any threats to get you not to testify?
No, sir.
This is your free and voluntary decision.
Yes, sir.
So let me go further. You heard your attorney said he rests, he's not going to call any other witness. That includes you, but no other witnesses. You understand that?
Yes, sir.
Is there any other witnesses that you wanted your attorneys to call and present to the jury?
No, sir.
Any other evidence that you wanted your attorneys to present to this jury?
No, sir.
You good? You satisfied with their performance?
Yes, sir.
Right. And everything that you wanted the jury to hear and listen to is before the jury. Is that right?
Yes, sir.
Thank you, sir. Let me ask, State, are you going to call any other witnesses?
No, Your Honor.
So the state's going to rest as well.
Yes, Your Honor.
What happened with Mr. Brendan Collins? He's not going to be used, I guess?
No,
Defense emailed me last night saying that they were not going to be calling him and he could be excused. I forwarded that email to Mr. Collins.
Thank you. So both sides have rested.
that's correct.
And now the pleasure is we can talk about the jury instructions, but what about the closing argument? We're going to do that on Thursday.
Yes, Your Honor.
So I'll tell the jury that come back Thursday. That's what the parties agreed to. And Tom will pack a bag. And Tom and Gary, you're going to talk to the jury about that, tell them what they need and what they can anticipate.
That's right.
And about the cars, where they park the cars.
Yes, sir.
There's a whole host of things he has to go over with the jury when they come back on Thursday about food and things like if there's special dietary things that they have to have. They have a list they go over with. All right. So, yes, sir,
Yeah,
there's something to discuss.
Yeah, as a legal matter, Your Honor, we'd like to, at the close of the defense case, renew our motion for judgment of acquittal, and renew all other motions and objections made. But our argument is the same with respect to the judgment of acquittal, that no reasonable jury could find proof beyond a reasonable doubt based upon the evidence that was presented, and that it invites to give this case to the jury would invite a verdict based upon speculation.
Thank you. They wish we heard.
And at this time, the state would submit that reasonableness could differ. There is plenty of evidence and argument in front of Your Honors upon which the jury could find, and the jury should find, the defendant guilty of first-degree murder as to both defendants. If Your Honor wants additional information as to each element on that, but the state would submit that the case speaks for itself.
Thank you. As I said, I'll defer ruling on it. So I'm going to bring the jury in and send them home. All right?
Yes, sir.
Let's go bring the jury, please. Good. Now we're in recess, man.
Thank you.
You bring your hands back on the right.
Jury entered.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of defendants, the counsel, the assistant attorneys, and the ladies and gentlemen of the jury. As you heard, ladies and gentlemen, the state is defense of the rest of their case. The state has no additional evidence or witnesses. Is that correct?
Yes, sir.
And the state is also rested. There's no further evidence in the case. So what I need to do is get the jury instructions done. I need some time to do that with the attorneys, and then they're going to present their closing arguments. There's an issue we had here that I can't be in session on this case tomorrow morning. So my thought is we're going to do closings all in one day on Thursday. All right. So don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence, and certainly no research. Now, when you come back on Thursday, Gary's going to discuss with you the sequestration. He'll talk about different things with you, what you need to pack and everything else. Because typically on that first night, we're you'll be in a hotel. All right, that's a whole idea of sequestration we talked about a little bit before that. So Gary's going to talk to you about it. He's going to explain where to park, what issues may come up, things like that, how to get in contact with us, things like that. The other family members or friends want to get a hold of you. He'll explain all that, how that works. All right, so when you come back Thursday, you're going to bring a tag with you. All right, so Gary will give you more explanation on that as well. All right. So just remember the admonition we gave you, not to discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, no research, we'll see you back here Thursday. All right, thank you, ladies and gentlemen, 9 a.m. Thursday. All right, let the record reflect the jury stepped out, Councilman Maine, along with the defendant. Anybody need a restroom break?
Yes.
All right, so how about we see everybody back in about 10 minutes and start with the jury instructions. Good?
Mayor, I gave counsel under a memorandum of law case law on the felony murder issue. I did talk about it briefly quite a number of months ago.
I don't remember, but I have your memorandum here. I assume you have it, Council?
Yes.
All right, thank you. We'll recess.
with some of that information because he had been interviewed after the fact by her, and he did not say those exact same things. He couldn't remember whether or not Melly was in his room or where exactly he was. But at the end of the cross-examination, there was a very short redirect, very short recross, and ultimately the state and the defense, they both rested.
Is that correct? Who's handling this for the defense?
Yeah, we do have them. I think there may have been some edits to that you received.
Thank you. Please be seated. Excuse me. For the record, once again, reflecting the presence of the defendant, the counsel, the assistant attorney, as well as ladies and gentlemen. A few minutes ago, I had my bail Gary leave on your chair a set of the jury instructions. All right. It has up at the top on the first page, it reads in the circuit court of the 17th Judicial Circuit in Fort Broward County, Florida. Case number 18-001872, CFA, Judge John J. Murphy, State of Florida Plaintiff versus Jamal Devins, defendant, charged with the court. Does everybody have one of those? Yes?
Yes.
All right. So what we're going to do is read the instructions now. So we're going to start at page 3, where it says 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. 3.2, Statement of the Charge. Jamel Devins, the defendant in this case, has been accused in count 1 and 2 of the indictment of the crimes of first-degree murder. 7.1, Introduction to Homicide. Jamel Devins is accused of first-degree murder in count 1 and count 2 of the indictment. First-degree murder includes the lesser crime of manslaughter. Both are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Anthony Williams and/or Christopher Thomas were killed by Jamel Devins, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Jamel Demons may be found guilty of first-degree murder or any lesser included crime. Count 1, 7.2, premeditated murder, first degree. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Anthony Williams is dead. 2, the death was caused by the criminal act of Jamel Demons. 3, there was a premeditated killing of Anthony Williams. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Jamel Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed and discharged a firearm, you should find him guilty of first-degree premeditated murder with actual possession and discharge of a firearm. If you find that Jamel Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime, he did actually possess a firearm, you should find him guilty of first-degree premeditated murder with actual possession. If you find that Jamel Demons committed first-degree premeditated murder, but did not actually possess or discharge a firearm during the commission of the offense, you should find him guilty only of first-degree premeditated murder. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, had a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Jamel Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime, he was a criminal gang member or associate, as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, you should find him guilty of first-degree premeditated murder in the first-degree premeditated murder in the first degree as a criminal gang member or associate. If you find that Jamel Demons committed first-degree premeditated murder, but find that he was not a criminal gang member or associate, as defined below, you can find the defendant guilty only of first-degree premeditated murder. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means the organization was in existence during the time period charged in the indictment. Primary activities means that a criminal gang spends a substantial amount of time engaged in such activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion for criminal gang membership. Criminal gang member is a person who meets two or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by a criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with one or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of one or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang activity means A, an activity committed with the intent to benefit, promote, or further the interests of the criminal gang, or for the purposes of increasing a person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates, acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented, reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communications, text messages, facsimile, electronic mail messages, and instant messages, real-time communications with other individuals through the internet or other means. Count 2, 7.2, premeditated murder, first degree. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Christopher Thomas is dead. 2, the death was caused by the criminal act of Jamel Demons. 3, there was a premeditated killing of Christopher Thomas. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Jamel Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed and discharged a firearm, you should find him guilty of first-degree premeditated murder with actual possession and discharge of a firearm. If you find that Jamel Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he did actually possess a firearm, you should find him guilty of first-degree premeditated murder with actual possession. If you find that Jamel Demons committed first-degree premeditated murder, but did not actually possess or discharge a firearm during the commission of the offense, you should find him guilty only of first-degree premeditated murder. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Jamel Demons committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime, he was a criminal gang member or associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interest of the criminal gang, you should find him guilty of first-degree premeditated murder in the first degree as a criminal gang member or associate. If you find that Jamel Dennis committed first-degree premeditated murder, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of first-degree premeditated murder. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means that the organization was in existence during the period charged in the indictment. Primary activity means that a criminal gang spends a substantial amount of time engaged in such activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion for criminal gang membership. Criminal gang member is a person who meets 2 or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by the criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with 1 or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of 1 or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang-related activity means A, an activity committed with the intent to benefit, promote, or further the interests of a criminal gang, or for the purpose of increasing a person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communications, text messages, facsimile, electronic mail, and instant message real-time communications with other individuals through the internet or other means. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the first degree is manslaughter. Count 1, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Anthony Williams is dead. 2, Jamel Devins intentionally committed an act or acts that caused the death of Anthony Williams. 4, Jamel Devins intentionally procured an act that caused the death of Anthony Williams. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention of harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a mere negligent act, or if the killing was either justifiable or excusable, as I have previously instructed you. Those explanations of justifiable homicide and excusable homicide are in instruction 7.1, introduction to homicide. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. If you find that Jamel Devins committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm, you should find him guilty of manslaughter with actual possession of a firearm. If you find that Janelle Demings committed manslaughter, but did not actually possess a firearm during the commission of the offense, you find him guilty only of manslaughter. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A carried a firearm on his person, or B had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Janelle Demings committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he was a criminal gang member or associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, you should find him guilty of manslaughter as a criminal gang member or associate. If you find that Janelle Demings committed manslaughter, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of manslaughter. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means that the organization was in existence during the time period charged in the indictment. Primary activities means that the criminal gang spends a substantial amount of time engaged in such activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion for criminal gang memberships. Criminal gang member is a person who meets 2 or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by a criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with 1 or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of 1 or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang-related activity means A, an activity committed with the intent to benefit, promote, or further the interests of a criminal gang, or for the purpose of increasing the person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented, reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communications, text messages, facsimile, electronic mail messages, and instant messages, real-time communications with other individuals through the internet or other means. Count 2, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Christopher Thomas is dead. 2, Janelle Demings intentionally committed an act or acts that caused the death of Christopher Thomas. 4, Janelle Demings intentionally procured an act that caused the death of Christopher Thomas. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention of harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. The explanations of justifiable homicide and excusable homicide are in instruction 7.1, Introduction to Homicide. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. If you find that Janelle Demings committed manslaughter, And you also find beyond reasonable doubt that during the commission of the crime, he actually possessed a firearm. You should find him guilty of manslaughter with actual possession of a firearm. If you find that Janelle Dennis committed manslaughter, but did not actually possess a firearm during the commission of the offense, you should find him guilty only of manslaughter. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to a expel projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Actual possession of a firearm means the defendant A, carry a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If you find that Janelle Dennis committed manslaughter, and you also find beyond reasonable doubt that during the commission of the crime, he was a criminal gang member, associate as defined below, and the aforementioned activity was committed with the intent to benefit, promote, or further the interests of the criminal gang, then you should find him guilty of manslaughter as a criminal gang member or associate. If you find that Janelle Dennis committed manslaughter, but find that he was not a criminal gang member or associate as defined below, you should find the defendant guilty only of manslaughter. Criminal gang means a formal or informal ongoing organization, association, or group that has one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Ongoing means that the organization was in existence during the time period charged in the indictment. Primary activities means that the criminal gang spends a substantial amount of time engaged in such activity, although such activity need not be the only or even the most important activity in which the criminal gang engages. Criminal gang associate means a person who A, admits to criminal gang association, or B, meets any single defining criterion of criminal gang membership. A criminal gang member is a person who meets 2 or more of the following criteria. A, admits to criminal gang membership. B, adopts the style of dress of a criminal gang. C, adopts the use of a hand sign identified as used by a criminal gang. D, has a tattoo identified as used by a criminal gang. E, associates with 1 or more known criminal gang members. F, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. G, is identified as a criminal gang member by physical evidence. H, has been observed in the company of 1 or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. I, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. Criminal gang-related activity means A, an activity committed with the intent to benefit, promote, or further the interests of a criminal gang, or for the purpose of increasing a person's own standing or position within a criminal gang. B, an activity in which the participants are identified as criminal gang members or criminal gang associates, acting individually or collectively to further any criminal purpose of a criminal gang. C, an activity that is identified as criminal gang activity by a documented reliable informant. Or D, an activity that is identified as criminal gang activity by an informant of previously untested reliability, and such identification is corroborated by independent information. Electronic communication includes, but is not limited to, photographs, video, telephone communication, text messages, facsimile, electronic mail messages, and instant messages, and instant message real-time communication with other individuals through the internet or other means. 3.5A, principles. If the defendant helped another person or persons attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or person did. If 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stage for the defendant as to each material allegation in the indictment through each stage of the trial, unless it is overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt does not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, or one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weigh the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or in part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment is, in his own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the court. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9, Section A, defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take a witness stand to give testimony in the case. 3.10, rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at them. 4, remember, The lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accordance with the law. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict must not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 3.12, verdict. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you. They are as follows. 3.12, A, subsection A, single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The verdict, I don't believe you have that in the package. I have it here. The verdict starts out, has at the top the style of the case. That's what we refer to as the style of the case. It reads, in the Circuit Court of the 17th Judicial Circuit in Fort Broward County, Florida, case number 19-001872, CA10A, Judge John J. Murphy, State of Florida, plaintiff versus Jamel Demons, defendant, verdict. Count 1. We, the jury, find as follows as to the defendant in this case. And it goes on, parentheses, check only 1. A, the defendant is guilty of murder in the first degree as charged in the indictment. B, the defendant is guilty of manslaughter, a lesser included offense. C, the defendant is not guilty. It goes on further. It says, if you find the defendant guilty of any of the crimes listed above, you must answer the following questions. 1, during the course of the crime committed, did the defendant, Jamel Demons, actually possess a firearm? Then you check the appropriate box, either yes or no. It goes on in paragraph 2. During the course of the crime committed, did the defendant, Jamel Demons, actually discharge a firearm? You check the appropriate box, either yes or no. Question 3. During the course of the crime committed, did the defendant, Jamel Demons, actually inflict death or great bodily harm to Anthony Williams as a result of discharging a firearm in his possession? Again, you check the appropriate box, either yes or no. The verdict form goes on. Question 4. Did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of the criminal gang? Again, you check the appropriate box, either yes or no. And then it goes on to say, associated with all this blank day of blank AD 2023 at Florida, Broward County, Florida. There's a place for the four-person sign and date the verdict form. Then there's a second verdict form for count 2. Again, it has the style of the case up at the top, and it reads, verdict count 2. We, the jury, find as follows as to the defendant in this case, check only 1. A, the defendant is guilty of murder in the first degree as charged in the indictment. B, the defendant is guilty of manslaughter or lesser included offense. C, the defendant is not guilty. Then goes down further and says, if you find the defendant guilty of any of the crimes listed above, you must answer the following questions. 1, during the course of the crime committed, did the defendant, Jamel Demons, actually possess a firearm? Again, check the appropriate box, either yes or no. Question 2, during the course of the crime committed, did the defendant, Jamel Demons, actually discharge a firearm? Again, you check the appropriate box, either yes or no. Question 3, during the course of the crime committed, the defendant, Jamel Demons, actually inflict death or great bodily harm to Christopher Thomas as a result of discharging a firearm in his possession. And then again, check the appropriate box, either yes or no. And it goes on. Question 4, did the state prove beyond a reasonable doubt the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of the criminal gang? And again, you check the appropriate box, either yes or no. It goes on further, so associated with all this blank day of blank AD 2023 at Florida, Broward County, Florida. And again, there's a spot at the bottom for the 4-person to print their name and sign and date the verdict. Is there any objection to the instructions of published and open court by the state?
Yeah.
By the defense?
No, sir.
Ladies and gentlemen, we're going to go to the second page of the instructions. It's called closing argument 2.7. And it reads as follows. The state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State?
Yes, Your Honor. Ladies and gentlemen, at this time, I can get up here before you and say the defendant is guilty of murder in the first degree. I can say that because you have sat through 16 days of testimony, and because back when you first started here, some of you as early as April 10th, you agreed to follow the law. And the law is clear that this defendant committed 2 counts of first-degree murder. I now have the opportunity to explain all of the evidence, because sometimes you get it piecemeal. What does this piece mean? What does this mean? So this is where we have the opportunity to show you how everything fits together. So I'm going to start by I also want to thank you for showing up. You received a summons. You complied with it. You came to the courthouse, and you decided to do your civic duty. We appreciate that. As I said before, we cannot do our job, and this judicial system does not work without you being here.
Counsel, can I see the sidewalk? Ladies and gentlemen, I just received a message that one of your members needs a election break or to take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in present. Please just leave your notepad and the jury is welcome from your chair. Thank you. Good. All right, we'll recess. Thank you.
Well, it's an interesting, the penalty phase is going to be.
Please open the argument. You ready, counsel? You may proceed.
So here's what we start with. Detective Moretti has an investigation that starts on October 26th of 2018. We have 2 dead bodies that are dropped off at Memorial Miramar, Christopher Thomas and Anthony Williams. We have Portland Henry, who's lying about anything and everything. He's lying about the location of where it happened. He's lying about when it happened. He's lying about Mr. Demmons, the defendant, being in the car at any point that evening. Totally omits that. We then have the cover-up that begins. So the question is why? Why does there need to be cover-up? Because there was a murder that was committed, ladies and gentlemen, that's why. There were 2 murders that were committed. And so from here, we're going to talk about and explain what we have, right? So Detective Moretti and the Miramar Police Department have to answer 4 questions. Who, what, when, and where? And so for the where, I want to start with where did the lethal shots come from? And let's start and focus on that part of the investigation. So the where, we looked at Chris Williams. If you remember, Sergeant Williams came in and testified and showed you how Blue Star works, showed you how shooting reconstructions are done with the trajectory rods. This explained how Miramar had made a good attempt, but they lacked training. So he came in and went through and is able to explain, as an expert in shooting reconstruction, what happened in this car. So we're going to start on the trajectory rods. If you recall, on the outside, the most important aspect of the ones on the outside of the car is they show that this was not a drive-by. That they're coming in at 90 degrees, that there's no keyholing. If you remember, you learned about keyholing, that would be an angle of entry on that. So he then showed you the Blue Star. And if you recall, ladies and gentlemen, this chemical reacts no matter how many years later, no matter what attempt at cleanup is done. The chemical is still going to react to the presence of the blood. So then you have that reaction. And that reaction, ladies and gentlemen, tells you that someone is sitting in the seat. Because, as Detective Williams illustrated, it's where the Blue Star isn't. So there is no blood. There's no blood where someone's would have been sitting. There's no blood where their legs would have been, and you can see on the V that's indicated on that. And there's no blood on the back of the seat. So ladies and gentlemen, what does that tell you? The killer was sitting there. And there's no blood because something was blocking it from getting onto that area of the car. So what do we know as well from this car? We know that there was also that this door was closed. How can that be said? Because, ladies and gentlemen, the blue star here shows that this door was shut because there was blood on this door handle. You have from this as well the headliner. So the headliner shows directionality. The headliner shows the way Anthony Williams' head was positioned when he was shot. That's one aspect of it. That DNA that was tested is all Anthony Williams, but we'll get to that. So the DNA, very strong support. 51.2 septillion times more likely to be that of Anthony Williams than any unrelated individual in the world. That was from Kurt Rhodes. If you recall, he was the expert on DNA. He told you and taught you how DNA is done, how everything works. So now putting those two things together, you can say, and the evidence shows, Anthony Williams, the way his head was in that Jeep, is that he is sitting in this front passenger seat, and as you can see, all the blood is dripping down the back of the seat. That tells you, ladies and gentlemen, and from the angle of entry when we get to the medical examiner's information, that his head was right here. So then we have one of the things that Detective Williams relied upon was the shirt of Cortland Henry. If you recall, there was a spot of blood on the front of the shirt. That blood, as Kurt Rhodes then told you, belongs to Anthony Williams. What does that tell you, ladies and gentlemen? That during the course of this shooting, Cortland Henry has his back against the driver's seat and is driving wearing this shirt when the shooting occurs. You know from that he is not the shooter. Why? Because if he was the shooter, the angle to get that wouldn't have the blood on the front of the shirt. It would have it coming across the driver's side and towards the side of the shirt, not the front. So on here you have the blowback coming there, and that's, again, 32.2 septillion times more likely to be the DNA of Anthony Williams. So then we have the back of the shirt. And so if you recall, the blood on the back of the shirt is right here. And that blood, Christopher Thomas, a single source profile. So what does that tell you, ladies and gentlemen? That tells you that Cortland Henry didn't fire the fatal shot for Christopher Thomas. Here's why. That blood is coming from Mr. Thomas when he's shot. The blood's only moving like that, as you heard from Sergeant Williams, when there is a pulse, when there is pressure. Remember the garden hose analogy that he used and talked about? That's when you're getting the blood that's going to be coming out of the body. And on that, so from there, you know, Cortland Henry is ducked over and flinching away from Christopher Thomas. So he cannot get that shot on Christopher Thomas from where he is sitting in the driver's seat. Even if he was in the back seat. Let's argue that for a second. To get the blood there, he would have to have been completely turned facing backwards to Mr. Thomas and then turned and shot over his shoulder to get blood on the back of the shirt. That's not reasonable inside of a car. What is reasonable is that he's driving, the shot happens to Anthony Williams in the back of the head, blood gets on the front of the shirt. He flinches, comes down, shot happens to Christopher Thomas, blood gets on the back of the shirt. So that was the other aspect that we learned from Anthony Williams, because there was the entrance and the exit wound. So from there, ladies and gentlemen, you can tell, again, the side-to-side orientation of the head, because that front passenger window is blown out. That tells you that his head was not upright, but it was leaning over to the side. Because if you recall, the entrance on Mr. Williams is back behind his left ear, and the exit is up here in his hair. If he was sitting up and awake and knew what was going on, you would expect to find a projectile in the headliner and the roof of that Jeep, but you don't. Instead, you know, based on his head angle, that it goes out the window, blows out the glass. For Christopher Thomas, he is in the rear. So what do you know about Christopher Thomas's wound? That it's coming in at almost 90 degrees on the left side of his face, and that there is stippling. You learned about stippling, the imprint of unburnt gunpowder into the skin of a living human being. Powder tattooing is also called. So on Christopher Thomas, you learned from Sergeant Williams, as well as from the medical examiners, that the firearm that inflicted that wound was approximately 3 inches to no more than 3 feet. Sergeant Williams said his estimation is no more than 12 inches away. And so why is that important? Let's go back and argue with Cortland Henry. If Cortland Henry was making these shots from the driver's seat, you would expect Anthony Williams to be covered in steel, because they're that much closer and nothing would be blocking or impeding that shot. But if the shot is instead coming from the rear passenger side, you're not going to have that same stippling on Anthony Williams because the seat's in the way. Cortland Henry, there is nothing blocking it, so you have the stippling. So ladies and gentlemen, that's one of the things that you would notice, and the differences that show that why it could not have been Cortland Henry in the driver's seat with this weapon. We know it can the backseat passenger, it could have been, because there is stippling. If it was a backseat passenger was shot by the driver, you wouldn't see that pattern of stippling because they couldn't get close enough to make that pattern in that imprint. So then we have all the drive-by on the trajectory routes that we talked about briefly. But this one is important because this is talking about strike K. So why is strike K important, right? Strike K comes in and hits the front of the rear door. That tells you that that door was open when that drive-by was staged. Because as you heard from Sergeant Williams, if this was actually a drive-by, this is what you would have seen. Strikes coming in at different angles, at obtuse angles. There would be angles of entry that would show either a pattern of speeding up or slowing down. But instead, you have them coming in at 90 degrees. And that goes for the front, on the driver's side door, the rear driver's side door, and then you have strike K going across. And remember, this is, Chris Carter took this picture that shows you where strike K impacted this door. If this door had been closed, you would expect it to be going into the speaker. That's where you would expect it if it had been a closed door. That's not what happened. Also, if that had happened during a drive-by, whoever was sitting in that rear driver's side passenger seat would have had a projectile right through their knees. That was the path of that bullet. Talking about as well on the driver. If you recall, ladies and gentlemen, projectiles are found underneath the brake pedal. You don't see any injuries on Mr. Henry. He got out of that car too. So the shots from the back of the car, same angle of entry. They're not coming from the side. They're not coming in like there's any difference. So now, ladies and gentlemen, I have to talk about the medical examiner's information. I know it's difficult. So what I'm going to do is I'm going to put a picture up briefly, then I'm going to move to a blank slide to talk about it. So everyone, I'm not trying to traumatize anyone. It's part of the case and it's evidence, so I apologize. So as you learned, Anthony Williams' autopsy was conducted by Dr. McDougall. Dr. McDougall, if you remember, had COVID. She came in and testified. So again, we have Anthony Williams. What did you learn during the course of Anthony Williams' autopsy? You learned that this is one of 3 times that Dr. McDougall could ever testify what was the fatal shot and which shots were postmortem. And so I'm going to move on, and the next picture is going to show the fatal shot. Again, A is the entry wound, and E is the exit wound. And again, that shows the angle in which his head was positioned. It also shows the lack of stippling, showing that that firearm was further away than that of the wound that was inflicted on Christopher Thomas. So then I'm going to show you for comparison the difference with the post-mortem, where it's white, there's no hemorrhaging, there's no signs of life, bleeding on these wounds. And these are the ones, if you recall, to his shoulder and to his torso. And so the one from his torso, which is B, came in through the side of the car and was into his lung. And if you recall, the one that's site C came from one of the shots through the back of the car and into his shoulder. Moving on to Dr. Sodders with Christopher Thomas. As to Christopher Thomas, you learned about the stippling and the pattern that's on it. You learned the distance determination, and you learned that the wound through his head was the one that caused his death. And that was the one for which he was allowed. You learned that when you're stippling, those are those tiny black implanted bits of gunpowder. So if you recall from George Bello, he drew the cone. You have a firearm, and as the parts from the firearm that are expelled. You have the projectile that goes forward, and then you have the cloud that gets increasingly bigger as it travels away from the muzzle of the gun. The example, if you take a handful of dust, sand, and a golf ball. You learn golf ball is going to go the farthest because it has the most mass. It has the most weight to it. So the most energy can be transported to it. The golf ball is like your bullet. The sand is your unburnt powders of gunpowder. It's going to travel, not as far, but it has more mass, so more energy can be transferred to it than that of the dust. The dust falls out quickly. That's why we can say it's not 3 inches, but that's why they can say it's less than 3 feet from the medical examiner's perspective. So going to the wounds on his back. Again, no signs whatsoever of any blood, hemorrhaging, in any of those wounds. There are projectiles that intersect his lungs. You heard Dr. Saunder testify that the lungs bleed profusely if a person is alive. So ladies and gentlemen, from all of this, at this point, the state has established that there was someone in that rear seat. Someone who was in that rear seat is the person who committed this murder. And so now the question is who? So I'm going to show you now why the state has proven who was Jamel Dennis. So we have the studio video. This is going to go through and you can track the defendant wearing that lyrical lemonade sweater all the way out to the Jeep, where he gets in the spot the murderer sat in. It's important to notice, ladies and gentlemen, that phone, always, always, always in his hand. He doesn't let go of it, it's still in his right hand as he's going to go get in that rear driver's side seat. Same with that satchel. And recall, ladies and gentlemen, that satchel and the one that you see Christopher Thomas wearing are never recovered. So they were taken out of the car by the defendant. So let's talk about the mobile records and the phones and why this is important. Okay? So the question is, are the phones themselves, do they know where they are? And then does the network know where the phone is? So this, ladies and gentlemen, is one of the exhibits that was put in, and this is the phone of Mr. Devens at 3:18 a.m. If you will notice that there is right here a camera icon, and that is located at 805 Northeast 4th Avenue, because that's the camera from the studio that you just watched. And the blue pin is where the network thinks the phone is. Is it perfectly precise? No. But is it accurate? Yes, within a football field, right? We learned that less than 78 meters is the range on those bands for the timing advance, but this isn't the timing advance. This is where the network thinks the phone is. Ladies and gentlemen, the phones work. You know the phones work because in your daily life, when you need to go anywhere, you go into a mapping app and you put an address in. You don't have to know where you are to get somewhere because the phone knows where you are. These are things that you use on a daily basis. It's common sense. The phones work because you've used them. We've relied on them for years to show exactly how to get someplace. Look, in a populated area like this where there's multi-story buildings, okay, maybe it's a little bit more difficult to say precisely where a phone is. You can order a pizza by sending a drop-in. The phones work, ladies and gentlemen. We rely on them in our everyday life. So let's go and talk about the T-Mobile and the Sprint records. And so, ladies and gentlemen, what I'm putting up here is what I believe the evidence reflects. This doesn't go back with you. You don't get to take a copy of this into the back, but this is all things that are in evidence. This is a summary of them. So these are all the phone numbers that were in use in October of 2018. I am not suggesting they are still being used by these individuals. So at this point, the state has established, based on the business records from Sprint, Christopher Thomas, 772-713-2341. Anthony Williams, 954-248-9081. Mr. Demons, 772-713-9807. Cortland Henry, 561-720-3210. Janie King, the mother of Mr. Demons, 772-501-6942. Jameson Francois, track, the manager, 954-376-9158. Frederick Gibbons, the Louisiana-based rapper who lived the next community over, 225-529-5054. And then Octavius Withers, one of the other individuals in the red Mitsubishi, 954-371-7895. So from these phone numbers and those records are where we're getting the information as to where the people work. So ladies and gentlemen, I encourage you to go through and look at those records. Look at who the subscriber is. Jamie King was paying for the phone of Anthony Williams and Jamel Demons. Doesn't mean she was using it. In fact, she's listed under the billing entry, and that's her number. So you have that, and that's the 772-713-9807. And you can tell the date the service began, November 30th, 2017. Ladies and gentlemen, it's important to look at these things and things that start before the murder. Because when people are creating email accounts, when they're setting up social media, when they're buying phones, years before, they're not trying to hide anything at that point. So I submit to you that those are things that are reliable because there's no motive at that point to lie. So we have, again, like I said, she's under the billing for Miss King. So we have Cortland Henry. And so if you recall, Detective Moretti talked to you about Cortland Henry because it was the question, oh, it's so weird he doesn't have a phone. Well, you learned that the phone that he had was a pay-as-you-go phone. So it was a minute phone. And you also learned that every single phone call that came into that phone on October 26th of 2018 went straight to voicemail. What's a reasonable inference, ladies and gentlemen? The phone wasn't on. He didn't have minutes, or it was broken. That's what those records show. They don't show Mr. Henry making a ton of phone calls and passing the phone off to someone else. No, they show a phone that was not operating. So looking at the CDRs, so this is for Mr. Demons, the 9807 phone number. What I've done, 840-34 at the top, that's going to be, but for the time in question, October 26, 2018, you subtract 4. That's the same whether you're looking at the CDRs, whether you're looking at the Facebook or Instagram records. So that way you can help and cross-reference to see what's going on with an individual phone and where that phone is when these messages are being sent and when the social media is being accessed. So if you recall, ladies and gentlemen, we learned that the 805-610, we learned that the 805-637-7249, if you see an incoming phone call, and then that immediately outgoing to that number, it says it goes to voicemail. So right there, you have at 5:03 a.m., Jamie King calling the phone of Jamel Demons, her son, and being sent straight to voicemail. Then you have an incoming phone call from Frederick Gibbons, free domain, that lasts 491 seconds. You then have another incoming call, only 11 seconds, and then Jamie King again sent to voicemail. So let's talk about the surveillance footage. And I know, I warned you ahead of time, there are some parts of this that are incredibly boring, utterly tedious, but they're important. And sometimes it's the smallest details that show that, look, this is what it says it is. So you have here 3:35 a.m., 36 seconds. And as you recall, this is the camera that sits on 595 on the entrance and exit to the express lanes. We learned from Detective Moretti that the express lanes toll camera all the way out past 136th Street. So ladies and gentlemen, from here, you know from the studio at 3:19 a.m., we're now 3:35, 16 minutes later. We have 2 cars, and you can go and pull this up. And if you need any assistance with doing that, we'll be happy to bring it back up in court and show it to you. You have 2 cars, and you can watch. So the top lanes are looking east towards Fort Lauderdale. So when you watch these videos, you'll see 2 cars that come here on the eastbound, and then they're going to pop up down here on the westbound camera, and they're heading west. And ladies and gentlemen, I submit to you that if you watch these 2 cars one red, one right. You will see them come up here and go to the left to get onto the ramp over to I-75 South. You can see here the lights going to the Sawgrass Expressway up to the Panther Arena. But if you watch those two cars at 3:35, that's what you will see. They go over to the left, head south towards Miramar Parkway. And so what you've learned, again, we have the camera icon, and then we have where the phone suggests the network it says it is. Blue dot right there at the bottom. Again, meters, not miles. We then have McDonald's, 3:47:56 and 3:46:57. So 1 second apart on those two cameras. And there, remember, we saw the red car go first, then the gray Jeep on 595. You're looking here, red car, gray car. So on surveillance footage, when a business, a private residence, puts up surveillance cameras, they're not there for the benefit of law enforcement. They're there for the benefit of that business. So they're not required to capture the street that goes by. They're not required by any law to maintain those videos for any longer than they feel is necessary. They're there to make sure that if someone's coming through and burglarizing their business, they capture that information. The fact that they also happen to catch the cars going by is dumb luck. But this is not just dumb luck, because this is one of the parts of the investigation that Detective Moretti talked to you about. That they went out and went to multiple businesses. And look, these aren't officers that have been there 2 weeks on the job. Detective Moretti talked about, yeah, I've done tons of investigations at Walmart. I know their video retention policies. This is their jurisdiction that they are intimately familiar with as to where these cameras are and what they show. If you have a camera that's pointing in the completely wrong direction, you don't need to waste time to go in and look at something that's not going to show you anything. Or if you know the data retention period has already passed, because most are 7 days or less, you don't need to go back and do that again. So if you look at, again, we have the McDonald's. This is where the network thinks the phone is at 3:47. Meters, not miles. But this is showing you that those records are accurate. They're not explicitly precise, but they're accurate. Going to 3:53 a.m. This is the Montessori Academy. So ladies and gentlemen, you can see there's the Montessori Academy, and there is traffic. There is a car that is consistent with that gray Jeep going by at 3:53, at 4:06, and again before 4:20. You can watch that and look at that. It's not like there's no cars, there's nothing out there. There is things that corroborate that cell phone evidence. We have Sunset Lakes. That shows, and again, 3:50 a.m. So ladies and gentlemen, you learned a lot about the geography of Miramar and Fort Lauderdale and the distances between. You learned from 805 Northeast 4th Avenue in Fort Lauderdale, Florida, to Sunset Lakes, the 40th Street visitors entrance. You're looking at about 31 miles. Detective Moretti talked to you about driving that route, and rather than spend 45 minutes doing that drive, he instead did the 16-minute version flying over to be able to show you all of these locations in a much quicker, expedient process. So you know that the red Mitsubishi goes 30 miles in 30 minutes. That's an average speed of 60 miles an hour. And so you have in that the phone of Dontavius Withers. Mr. Withers has been identified as the person who was driving. And you have Travion Glass in that front passenger seat. Ladies and gentlemen, watch that video, please. You can see Mr. Glass moving his hands. You can see that he's awake at the time at this guard game. Watch it. If you need help, again, we're happy to assist. So then we have 4:03 a.m. So at 4:03 a.m., ladies and gentlemen, we have a very specific location the network thinks the phone is. And this goes back to being in the big city, right? We're here in this courtroom. Right there, we can see 3rd Avenue out the window. We can see the New River. Phone doesn't know if we're on the 4th floor, 5th floor, 6th floor. But we could be anywhere in this building, right? That's the beauty of Pembroke Road and US 27. Because what you've learned, ladies and gentlemen, is that on the west side of Highway US 27, there is a canal. You've learned that 208 Avenue is gated on the north and the south ends. That there is a Pembroke Pines fire training facility out there, so it's locked. You've learned that at the end of Pembroke Road, out here to the east on this map, there's another set of closed gates that prevents any further eastern traffic. You've learned that there's a waste management recycling facility out there. Again, another gate, an area you can't get into easily. So because of that, that limits the places the phone can be. It's not in a helicopter, it's in a car. And we'll get into that in just a little bit. So let's talk about the timing advance. For Mr. Demon's phone, I want to make sure it's clear when you're going through outdoor stationary, I've highlighted in green. So from 319 outdoor stationary, mobile, 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 mobile. So 403 outdoor stationary, then mobile again, all the way until 440. Why is that important? Well, let's look at the pattern of travel. Let's look at what the phone is showing where it thinks it is. Ladies and gentlemen, just think about cellular telephones. Think about how they can tell you're mobile. Most human beings can't run 60 miles per hour on their feet. So if you think about the speed at which your phone is traveling, that's going to tell the cell phone company whether it's mobile, inside a building, or outside. If someone is outside, not moving, nothing's obstructing, there's no concrete, there's no rebar, there's no electrical wiring interfering with their phone getting a clear signal to a tower, to the satellite for GPS, that's going to tell them outdoor stationary. And ladies and gentlemen, this is common sense. These are things that you know on a daily basis that you have to deal with your own cell phones. You go into a really tall building, hard to get a signal. You have to go out to a window. And just because that is out there, ladies and gentlemen, doesn't mean that we're saying it's 100% accurate. We're saying that it is reliable on that it is also able to be corroborated by other evidence. What do I mean? 3:18 a.m., where it says the defendant is outdoor stationary, guess what the video at the studio shows? The defendant outside. When it says out here at 4:40 and 4:42, outdoor stationary, guess what the other evidence shows? The defendant outside sending a drop pin to his buddy from that phone. So let's talk about the pawn slip. Again, this goes to showing when you're not.
I'm sorry. It's a good time to do it.
Yes, sir.
I'm told someone needs a restroom break. We'll take a short recess. Do not discuss the case. Discuss the case. Present search and no research. Thank you. Stephen, hopefully you're going to share your
Jury entered.
Ladies and gentlemen, thank you. Please be seated. For the record, once again, we'd like to be judged of our jury, the defense, Dennis, Ms. Cohen, counsel rather, and the assistant state attorney. Counsel, if you're ready to proceed with your closing, you may.
So continuing on the pawn slip. Why have a pawn slip, right? Seems kind of silly. But again, this goes back showing that you're not planning on murder.
Excuse me, Eric.
Yes, sir.
Just keep moving, podium. Excuse me, here. Thank you. I'm sorry, go ahead.
When you are not planning a murder, you use your real phone number. And this isn't, oh, this was where I could be reached. He's pawning jewelry. You have this in evidence. And you heard from Amber Allen, who testified that that is the defendant's thumbprint. You have his signature, where he is stating that everything on that document, that the facts stated in it are true. There's a fact His cell phone number is 772-713-9807. So we go to the Department of Highway Safety and Motor Vehicles records. We have his name, driver's license number, his signature. The same driver's license number, signature, and name that you have on the consulate. Then you have the booking prints, where you heard from Deputy Maycock that yes, he took the prints of the defendant on February of 2019. And that is the same thumbprint that's on that booking print that's on that consulate. So let's talk a little bit about the CAST analysis. That was the FBI, Special Agent Brendan Collins. He looked at not just one phone, but compared and contrasted 2 phones in each of these particular analysis slides that he compiled. And those are in evidence, and you feel free to look at those and refer to those. So we have here between 3:20 a.m. and 3:57 a.m. 772-713-9807, Mr. Demon's phone, and the 9081, Mr. Williams' phone, are all tracking together. If you recall, when there's circles, Special Agent Collins is indicating they are using the same cell tower. He's not plotting in terms of the distance on those. That's all he's indicating with that. So this is showing the pattern of travel, that at each of these points, they're using the same cell towers. So ladies and gentlemen, you learned that the phones of Mr. Demons and Mr. Williams travel in from 3:20 a.m. in 40 minutes all the way out to US 27 in Pembroke Road. And so why is that important? You've learned from watching the videos of the geography how long it takes to get from the studio out to 184th and Miramar Parkway. That's about a couple blocks north of the Sunset Lakes 40th Street entrance. You've learned that. So now you know that how long it takes to go all the way up to Pines Boulevard, because as you've learned, Pembroke Road doesn't go through. You have to go all the way to Pines to get across. So then on the other side, you have Mr. Thomas and me, Ray Jeep, the deceased in the rear passenger seat, and Mr. Withers, the driver of the red Mitsubishi. And they're both on Sprint. If you recall, Mr. Demons and Mr. Williams, same phones, same phone plans. Mr. Thomas, Mr. Withers, both on Sprint. Because at this point, T-Mobile and Sprint were 2 different companies. They have since merged. Again, you're showing the same pattern of travel. From the studio, going north up to Sunrise, Sunrise down I-95, 595 across to I-75 south to Miramar Parkway. And they are showing consistently traveling together. Then we have Francois, track, his phone. Here's his alibi. He's home. This is the Margate, Toscana apartments that you've heard about and learned about. He is nowhere near US 27. He's nowhere near the recording studio. He's at his home in Margate, his apartment, until noon the next day. Then for some reason, at noon, on October 26th of 2018, Jameson Francois' phone is out there in that same US 27 in Pembroke Road location. And so is that of Mr. Demons. Very odd location to go to. Nothing out there, except evidence of a murder. And ladies and gentlemen, you know the number of shell casings that were found at that scene. And you know that there's at least A through Q fired into the outside of that vehicle, not including the ones inside the vehicle, in terms of the number of shots that are fired. But they're going back there. So going back to Mr. Demons' phone at 4:40 a.m., remember the timing advance bands. So at this point, at 4:40 a.m., you also have seen the Memorial Miramar video, where at 4:35, the Memorial Hospital is right here. At 4:35, 5 minutes earlier, Portland Henry drives the gray Jeep into the hospital with the 2 deceased victims. So you know where Anthony Williams is, you know where Christopher Thomas is, and you know where Portland Henry is, because it's on video. So then you have the timing advance band. And again, this goes to, where is the phone? Because the phone, you've learned, connects and talks to the tower no matter what. But the phone doesn't make outgoing phone calls on its own. The phone doesn't send text messages on its own. That takes user input. So Here's an example of the drop pin at 4:42 a.m. to Frederick Gibbons. This is from Special Agent Collins, showing where on this red band the phone would be based on the phone network records. Then we have the phone itself saying where it is. Pretty consistent. So let's talk about whose phone it is. And I know it was a lot of video of pictures to watch. I know that. I'm not going, and we all know that I can count to 500 and some. So I want to make sure that everyone understands why it's important as to who the phone shows. All of these photos, all of these FaceTimes show the defendant. There's not a single instance that's been put before you in that phone, which is in evidence, it states 64 of the extraction, and then the phone itself as well, that says, hey, this is so-and-so, I'm using Melly's phone. You don't have that, because it doesn't exist. Instead, you have this defendant using his phone, and he's the only person using his phone. And so, ladies and gentlemen, it's important to note that this isn't the polished, perfect shots. These are the outtakes. These are the ones that aren't suitable for public consumption, that aren't put out on Instagram, that aren't put out there to promote an album or anything like that. These are the raw images. That's why it's important to look at those. And ladies and gentlemen, just because there's a photo on this phone of something else, you take a photo of your dog with your phone, it doesn't mean it's your dog's phone. You're taking pictures of what's important to you. I submit to you, you can tell based on these photos and these videos what's important to this defendant. The videos. Just going to play one, but this is, like I said, a sample of the 1,000 some. This one is interesting because you see the reflection of the phone in the glasses. The videos also show, if you recall, the video of the Western Union. 772-713-9807, October 2nd of 2018. This is the only individual that is using this phone. Talking about the jail call. You heard about 6 minutes of this call, and of which part there's 2 minutes where it's silent. What is that? We learned during the course of that call that the phone, 772-713-9807, didn't have money to pay for the minutes for the jail call. So ladies and gentlemen, I'm going to remind you what that jail call said.
Hello, this is a direct call from an inmate at Broward County Main Jail. This call is subject to recording and monitoring. To continue, press 1. To disconnect, press 2. Thank you for using Securus. You may start the conversation now.
Hello? Hey, lady, why didn't you just call my phone where I got my credit card? You should have called my phone, baby, because I put money on my phone.
It's money on my phone.
No, you out of money instead of this. I just put my credit card on your phone now.
Yeah, over the year, you could have. Oh, yeah, my credit card.
Yeah, I don't know your credit card number because it asks for like your expiration date and your zip code. I don't know what your stuff is that's linked to that card. What is your 7-Eleven? Like 7-Eleven in July. What you doing, baby?
Yeah, I'm driving. Just my credit card. I'm gonna keep my credit card number.
Why don't you just check your phone? Because he said I was answering the phone, we're not supposed to. Yeah, oh, he just said he love you, keep your head up, and everything. And then, yeah, easy. Where's been checking your phone? I ain't been reading your stuff, but he got like text messages with him. I didn't know if you want me to call him or maybe on 3-way.
Call Jeff.
Who is that? Hold on. You got your number?
Yes, my phone. Jeff.
Oh, he did his son. Okay. Hey, okay, finish the GPS for 7-Eleven. Okay, Yeah, so I go under contact, you go under Jessica? Yeah. What's the number? It said I need space for recognition. 762-556. Seven? Oh my God, I'm trying to drive, trying to do this. Hold on, 762-556. Yeah, right here, real quick. I just like, hold on, I'm about to have a wire drive, so I can do this for you. But I'm trying to do too many things at once.
So what did we learn in that phone call? We fast forwarded through the part where they're putting the credit card phone number in. They use GPS. They find it reliable to find 7-Eleven. That's the defendant's phone. Why are we using calling my phone? That Mariah is there with Jamie King. And that is the phone number that's being called. It's being identified as my phone by the defendant. So let's talk about some of the text messages. And ladies and gentlemen, you will have those to go through and look at them. You'll have the one, and I submit to you that crazy or crazy lady is Jamie King. Go through, read those messages. You can see it's a mother-son relationship. I love you, kid, son. All of those types of endearments showing you who's using the 9807 phone. You also have with Anthony Williams. He's listed as the contractor's twin. Ladies and gentlemen, we've gone over the messages where you can see the animosity, that there is some tension between Mr. Williams and Mr. Demmons, where Mr. Williams is making it clear that, and I would fully agree, Mr. Demmons was a talented musical artist. Anthony Williams had not had that level of success. Christopher Thomas didn't have that level of success. They don't have that opportunity because the defendant killed him. But the defendant was making money. He was the one that was the revenue source, the meal ticket in the house. Look at the messages. Look at the tone of them. Look who's asking for money. Look at the way they communicate about things for the house, about food. And look at where Anthony Williams is saying, look, I'm the CEO. The others are artists. Anthony saying, myself, Mr. Demmons, Mr. Thomas, we're the CEOs. But at that time, Mr. Demmons is the one who's actually putting in the work, who's doing anything, who's making the money, who's recording the songs. You have the chat with Frederick Gibbons. And ladies and gentlemen, that is the one in which the defendant asked to be picked up from the side of Pembroke Road. That's that drop pin that we talked about in relation to the cast records. That phone is being used by the person who committed the murder. And ladies and gentlemen, the only evidence before you, the only evidence is that the only person that used that phone was the defendant, Jamel Demmons. So go through and look at some of the videos. You have the studio video. You have the brief clip of the documentary. Watch what the defendant's doing with his phone during that. Glued to that phone. Glued to it. So let's talk about the activity and the location data. What does this show? We have on October 25th of 2018, 8:14 p.m., a scent of a CF, or a current location, a drop pin. That one is sent to Anthony Williams. You can look at the messages and look at all this and verify all of these things. Then the next one going from the bottom up, we have 4:42:49 a.m. That's the first one on the side of 178, just south of Pembroke Road, mere blocks from the hospital. Then we go to the second one, 4:53:30. You can look and you can see based on the numbers how close those two drop pins are from one another. Negative 80.38, negative 80.38, 25.98, 25.98. And you can see the time difference between the two of those. And then this part is key. The next Wi-Fi the defendant connects to is not at his house, not at the YNW Castle, but at Frito Banks. Because, ladies and gentlemen, the defendant committed the murder, dropped off on the side of the road and then needs to find a way to get home. They can't go home because the other people in the red Mitsubishi, they didn't know what happened. And they need time to get their story straight. And police don't know about Frito Bang's involvement. In fact, police don't find out about Frito Bang and the picking up of this until February and March of 2019, after the defendant's in custody. So what we had to look at now, Frito's house Wi-Fi, 8:47. And then look, it connects back again automatically at 12:27. That further verifies and corroborates the trip back to US 27 Pembroke Road at noon that I submit to you was to pick up shell casings. Then we go back and we have the one that we did in open court, the one at 6:41 p.m. It is at that location at the video shoot. 10:27 at 3:02 a.m. That is the next time the defendant returns to that house. The YNW Castle, the 18521 Southwest 44th. Ladies and gentlemen, sometimes common sense is not so common. And these details are things that are not being contemplated after the murder. Because if the version that was brought in by Mr. Davis, the defense witness, is to be believed, that phone should have gone to the house. That phone should have connected to the YNW Castle Wi-Fi, not be sending drop pins all over the county and connecting to somebody else's Wi-Fi before finally going back to that house. So remember, that phone showed mobile all the way till 4:03 a.m. That's when it went outdoor stationary. So ladies and gentlemen, I submit to you, that's when that drive-by was staged and the victims were killed sometime between the highway at Miramar Parkway and I-75 and getting out to US 27. Because you learned they were dead for some time. And look, there's no way to put an exact amount on there, but hearts were not beating when that drive-by was staged. So then if we go into the steps. If you recall, the drop pins, 442, 1,397 steps, 945 meters. And ladies and gentlemen, you can go back, and this is in evidence, you can look through and see when the defendant's at the studio, in the recording studio, you don't see this type of movement. If the defendant was home in bed, you wouldn't have an answer. As to if it's 70 steps, 80 steps, 50 steps, you would have 0 if the defendant was home in bed with his phone. As you recall, 4:03 a.m. is when the phone is saying outdoor stationary inside of Pembroke Road 27. So let's go to Felicia Holmes. Felicia Holmes, I think it is safe to say, hates me. And I'm okay with that. Because my job is to prosecute a crime and prove that it happened. Ms. Holmes didn't show up for a summons. There are consequences if you do not comply with court orders. You were served a jury summons to show up, just as she was served a subpoena to show up. I'm not going to apologize for doing my job. But what I am going to say is remember her testimony. And I have to say, the photos are courtesy of Law and Crime, so I appreciate their allowing me to use those. Ms. Holmes did everything she could to not perjure herself. Because she didn't want to say she lied to law enforcement. Because that would get her in trouble. So she was this whole, I don't remember. But even with all of that, she did remember one very important detail. Mr. Devins on a FaceTime call with her daughter. So you know at that point, ladies and gentlemen, that Mr. Devins...
Objection.
There's no such testimony. Objected.
Thank you. Ladies and gentlemen, you are to rely on your own recollection of the evidence. This is counsel's explanation of what she believes is evidence. Proceed, counsel.
You heard from her mouth that she heard her daughter scream and that she spoke with the defendant on FaceTime.
Objection.
Thank you. Same ruling, ladies and gentlemen. You are to rely on your own recollection of the evidence. Proceed.
She was asked if it knew about a drive-by shooting because the cover-up has already started. And remember, Cortland Henry is at the hospital. 4:35. Mr. Demmons is not. But they've already worked out this story to try and get away with murder. Whatever was said on that phone call was so troubling and so disturbing to Ms. Holmes that she and her daughter then drove immediately to Broward County. She remembers Frito Bang's house. She remembers lunch. But doesn't remember the contents of the call, doesn't now remember the phone number that was used or anything like that. Doesn't know her 17-year-old daughter's phone number at the time. Ladies and gentlemen, common sense. A mother is going to know her child's phone number. And don't forget, ladies and gentlemen, that little detail about the $5,000 that she got, that wasn't from the state. She says, oh no, that was for a vacation. Ladies and gentlemen, that was hush money. That's what that $5,000 was.
Objection. There's no evidence of that.
Please, you ought to rely on your own recollection of the evidence. This is argument. See.
So if you recall, Ms. Holmes identified that driver's license in the Snapchat video. That's her daughter, Mariah Hamilton. You can see, again, one of the photos that was previously shown. Ms. Hamilton and Mr. Demmons spoke on FaceTime all the time. And Mr. Demmons took screenshots all the time. Always making content, whether on purpose or not. Every single time that you can see this is an example of showing this was his pattern. And ladies and gentlemen, remember Ms. Johnson from T-Mobile. The call detail records are just that, calls, not data. A FaceTime, a video communication, is a data usage on a phone, not a cellular telephone call. So you're not going to see a cellular telephone call on the CDR showing Ms. Holmes and Ms. Hamilton's phone call from the side of the road. Travion Glass, the red Mitsubishi. What did we learn from Mr. Glass? We learned that the red Mitsubishi did not stop at the gate. And ladies and gentlemen, that's consistent with the physical evidence, with all of these cell phones, with everything else that cannot be changed by a person's failure to recall, that is in the records, that is on video. That's what you can show to corroborate, show that he is being honest. Mr. Glass said, Mr. Demmons was not in the car, that red Mitsubishi, at any point on October 26th of 2018. Same 4 people got in, same 4 people got out. He recalled the different clothing the defendant was wearing at Frito Bang's house. And he authenticated those photos that Danny Polo first introduced, that those were from that evening. Where you see Anthony Williams sitting on a couch smiling, where you see Christopher Thomas animated standing up, where you see Jamel Demmons doing a handshake with the engineer. And look at those photos, ladies and gentlemen, because if you zoom in and you look up at the top of the one photo where the engineer is sitting down at the computer, Mr. Demmons is standing up, you can see the exact same screen grabs of the studio surveillance footage that you watched. You can see the red Mitsubishi and the gray Jeep parked just as they were. So Mr. Glass said that the red Mitsubishi did not stop. Just because you're in a courtroom doesn't mean common sense doesn't apply. If you fall asleep in a car and the lulling motion of the car driving puts you to sleep. That first red light, when you get off that interstate, wake you up. These are things that you can rely on in your own personal experience to say, oh, yeah, that makes sense. That the red Mitsubishi didn't stop. That the 30 minutes and 30 miles are consistent with one another. That there was no stopping on the side of the road. And also, there's no reason. There is no reason that's put before this jury whatsoever. Not in the phone records, not in the Snapchat, nothing that explains why 8 people that are going to the exact same location would stop on the side of the road. Just one person would switch a car. No reason whatsoever. And ladies and gentlemen, you can look at those videos and see the cars are tracking together. The phones are tracking together. All the way through until they get to 184th. So we have the memorial mirror mark that gives us that timestamp on Mr. Henry. And we also know that here Mr. Henry changed clothes. So we have in short sleeves at the studio, and now wearing long sleeves as he runs in to talk to Officer Amador, who was the detail officer working at the hospital. So what you have learned from this, and you can watch it again, they first bring in the body of Anthony Williams, who's that front seat passenger. Then they, in the pictures you can see from the Jeep at the hospital, they then recline that seat all the way forward to take out Mr. Thomas, and they bring Mr. Thomas into the hospital. I'm not going to play the video now, but so you know at this point that Cortland Henry has changed clothes. And that will become important again in a moment. So George Bello, I don't think he has dropped off your certificates and firearms, but I am sure they're coming. You learned that he is part of the Broward Sheriff's Office Crime Lab, Firearms and Tool Marks unit. That he is the manager of that unit. That he has worked in that particular area for a number of years, both here and in Dade County. And you learned more about firearms and how a casing is marked by a firearm, how a projectile is marked. And this is just some of the things that you've learned. Shapes of firing pins, breech face marks, extractor marks, ejector marks, lands and grooves, rifling, the class characteristics, which means every specific Glock 19 has these same class characteristics. The rifling, the lands and grooves, right? Those are going to be the same for each Glock 19. But then you learn the individual characteristics are the things that make each firearm unique. So what did you learn specifically on this casings and projectiles? So starting with the projectile, this was recovered from Anthony Williams. This was from his shoulder. We have the ones from Christopher Thomas, and this is just a sample of the 7 that were recovered. So what do you learn about all of these projectiles? You learn about the projectiles from the Jeep. And again, this is just a sample, not all of them. So you learn that numbers 13, 14, and 15, right? So those are going to be the ones from the Jeep. And the easiest way to reference all of these, ladies and gentlemen, is the G number. The group number, which is the one that's assigned by Miramar, and that's on the packaging for each of those particular items of evidence. So you learn that 13, 14, and 15, which came out of that Jeep, were all fired. 13 and 15 are definitely the same weapon. And 14 is very likely to be the same, but it has too much damage to make a full conclusion on that. So then on the ones from Mr. Thomas and Mr. Williams. That's the G44, 57 through 63. Again, some of them have both class and individual characteristics, which they could have been fired from the same weapon. And the rest have just class characteristics. And so then we have cartridge casing. So this casing is at the passenger, rear, driver's side, floorboard. The exact seat Mr. Demons was sitting in a plastic bag. This cartridge casing is found October 26th of 2018. Then we go to November 21st of 2018, where you heard about the testimony they had to use the canine to find these particular artifacts. All of these 8 casings are consistent and fired from the same weapon as the one inside the car. From this, and we went through the cantilevers, the lands, the grooves, the rifling on all of those. So we go through every single one. And that's G196 through 203. All right? They all match. And so you learn from George Bello that he doesn't have a weapon for comparison. And he gives a list, 30 or so weapons that could have caused this particular casing and projectile. Right? So you learned that without the actual firearm and the exact same ammunition, you can't do a range of fire or distance determination because there are things in each firearm that would affect that. You want to, in any scientific experiment, make as few variables as possible. If you don't have the gun, can't do it. So then you also learned that if you don't have the gun, you cannot match the casings to the projectiles. You can match projectile to projectile and casing to casing, but you can't match one to the other because there's different marks from different parts of the gun. Other important thing, George Bello specifically excluded Glock firearms because they have a different, very distinct type of rifle. So all those Glock-related firearm things that Jameson Francois, no relation whatsoever to this case. I can tell you that was not the murder weapon. I can't tell you that what specific gun was the murder weapon because it's never been found. There's never been another match to that to this day. So let's go to GSR. Sarah Helsell came in and testified from R.J. Lee. You learned GSR, primer, that's what she's testing for and looking at under the scanning electron microscope. Antimony, barium, and lead. That those three, when all three are together, are considered GSR. That is a gunshot residue particle, all three of them. You learned that Mr. Henry has one. One 3-component GSR particle on his left hand. And then there are 2-component particles, so either lead and antimony, lead and barium, or barium and antimony, right? One on his left hand and one on his right hand. So you've learned that some of those maybe show up, the 2-component particles, in other circumstances. But generally you see a third element. I believe she referenced brake pads, and you could also see steel. You don't have that here, right? So you have a 3-component GSR and a 2-component GSR, 2 of those. So the Jeep in 2023 even have more than 9 2-component GSR particles found 5 years later. They're still there. And that you heard from Chris Williams, who obtained those during the shooting reconstruction and sent them in for testing. So what does that tell you about Portland Henry? Ms. Helsell was very clear. She goes, I cannot say that GSR being there or GSR not being there means that someone fired a gun. She goes, there's 3 options. 1, they fired a gun. 2, they were in close proximity to someone that fired a gun. Or 3, they touched a surface upon which GSR was and it transferred to their skin. So ladies and gentlemen, with regards to the GSR, you also learned that it falls off very quickly. So you have a Jeep covered in 2-component particles. And you have Mr. Henry having 1 after changing clothes. What you don't have is an answer as to Mr. Demmons, because he was never tested. Because he didn't speak to law enforcement that day, he didn't go to the hospital. He was never tested for GSR. He did nothing on that. So you can't draw a conclusion one way or the other as to GSR because there is no answer to that. So again, George can't have a drive-by, have a casing right inside the car. Doesn't work that way. So then we get to Mr. Henry's statement. Part of the project. So you hear, I was getting sleepy, I'm almost home. Out of nowhere, I heard gunshots. I ducked down, almost crashed the car. Made available to you as well as the disc, but you would have to come out into the courtroom to look at those. So he's talking about and he's embellishing, trying to sell this story. Because there's no evidence that shows any sort of tire damage, any sort of rim damage whatsoever. But no description. No idea what type of car. Nothing on that. Because there wasn't one. But he's trying to build a cover story to take this defendant and separate him from the shooting. So as you learned, how Miramar Parkway is laid out. And you learned that the Miramar Police Department shut down Miramar Parkway and walked more than 2 miles. They walked from I-75 all the way to 184. And so when you look at Miramar Parkway and the geography of it compared to Mr. Henry's statement, it's interesting to note that the hospital is right there. If it happened as he stated, we wouldn't have differing timeframes on the postmortem wounds and the fatal wounds. That's a mile. From I-75 to 172nd, 1 mile. From 172nd to Pembroke Road, 1 mile. if that's where this happened, you would have evidence of it, and there is none. There's no casings, there's no glass, there's no projectiles. So from this, all of the cell phone records show consistent path of travel all the way across Miramar Parkway to 184. That is when everything splits. If you recall, Detective Hector Bertrand testified when these maps were placed into evidence. So let's go to the DNA. On October 26th of 2018, Chris Carter swabbed the rear driver's side door handle. It wasn't until later, because as you can tell, are fluid, they evolve. Let's not also forget, we had 15 months of a global pandemic when nobody came into this building. So this isn't tested until later on. Doesn't change what's on the swap. As you learned from both Kurt Rhodes from this door handle with the blood on it. Here's what you have. Very strong support for Christopher Thomas. Limited support that Anthony Williams is also included. And very strong support that Jamel Demons' DNA is on that door. So ladies and gentlemen, when an item is tested, it doesn't change the results. There are many factors that go into when an item is tested. Witnesses aren't being cooperative. Have to come up with a different way to prove it. This is the other way to prove it, ladies and gentlemen. That his DNA was on that door handle. Let's go to the trace evidence. This is a very unique piece of evidence that you don't see very often in any case. And what does the glass on US 27 and Pembroke Road tell us? Let's think about this. The glass is on the north side of the road. Why is that important? So if you have Melly's murdermobile on the south side of the road, stage the drive-by, you now have a ton of shattered glass. Some in the vehicle, some hanging on. You have to leave that area. How do you go from facing eastbound on the south part of the road to going back to US 27, because that's the only way out, as you've learned? Pop a U. What happens when you pop a U-turn? All the glass that was in that vehicle is then thrown out to the north side of the road as they make that U-turn. So ladies and gentlemen, that's why this glass was collected, and that's what it shows. It shows the pattern of travel and the fact that this did happen in Miramar on the south side of Pembroke Road. So you have the different populations of glass, and you heard from James Morano that the two different types that he went through and he compared them, and that they are consistent, both the standards as well as the ones on the side of the road. It's another thing and another level of showing you that this Jeep was out there, that this was the cover-up, that this was not a drive-by. So let's go to the gangs. And ladies and gentlemen, I'm limited on time in terms of what I can talk about. So in some areas, I'm going to be brief. This is one of those. Ladies and gentlemen, the evidence clearly shows the defendant is a G-Shine blood family member. And so for the purposes of the jury instructions that His Honor just read to you, you have to determine if at the time of this offense, if the murder of his two friends benefited the defendant. And in benefiting the defendant and promoting or benefiting his position in the gang, it then helped the gang itself. You learned many, many things about G-Shine, the organization. And I think the most important thing to look at is to compare and contrast the public facing, the YouTube videos, the gang signs, the music videos, the motto for the album, right? Those could be an actor. That could be a show put on for the public. But look at the private side, the not for public consumption. Look at those messages. And look at that, there is a benefit to both sides. The gang gets notoriety, gets money. The defendant, he gets access to different venues. He gets protection. He gets a sense of whatever we want to call comes along with being a gang member. And so, ladies and gentlemen, you heard lots of testimony from Detective Danny Polo as to what the primary activities of G-Shine, of GKB, Gangster Killer Bloods are. You learned that they're the enforcers. You learned that they are violent. You have that information before you in those text messages. The nighttime drive. This shows the conditions under which this murder took place. This is not an area you find by accident or misfortune. This is a planned drive out to the edge of the Everglades where there's not going to be any witnesses. This shows pre-planning and premeditation. This is a consistent, quick, no stops, no detours ride out here. And so some of the things that you can look for premeditation, the nature of the weapon used. So having the firearm already. And like, how do you know that they had the firearm already and the defendant had the firearm already? Because he asked for it the day before. Remember, on October 25th, Jamel Demons, 9807, sent a text message to Anthony Williams asking, where's the firearm? FYE. And Mr. Williams says, it's in here with us. And if you look at the context of the conversations, that shows they were driving down from a location in Stewart, and they were driving to pick the defendant up at the airport. Mr. Williams brought his own murder weapon to the defendant. Look at the rest of the conversations. There's multiple discussions about this firearm. Where's the firearm? From Mr. Williams to Mr. Demons earlier on. It's in my closet, third shoebox. This is discussed. That is not a lighter. That is not a really great song. That's a firearm, ladies and gentlemen. There is discussion about firearms. The presence or absence of adequate provocation. When you look at that and you're looking at this case, they were friends, right? They were buddies since they grew up. But look at the stress being placed on this defendant as the only one bringing the money in, as the only person who's paying the bills. Look at the tension on there, right? Look at the issues and concerns with Mr. Williams, Anthony Williams, and the defendant's mother, that they're fighting in our messages on there to that effect. So look at, for premeditation, you can also look at the manner in which the homicide was committed. Anthony Williams was shot in the back of the head. That was planned for when he was sleeping so that he could not fight back. That was a premeditated, planned killing of Anthony Williams, where there would be an alibi already discussed. So then, Christopher Thomas. Premeditation, as the judge instructed you, does not require days, weeks, months of planning. Premeditation can be formed quickly. Example we use in jury selection. Going to your mom's house on Mother's Day. You forget to bring flowers. You reach down, pull some flowers out of her yard and give her to those. That is premeditation. that is thinking about something than doing. Ladies and gentlemen, I submit to you the murder of Christopher Thomas was premeditated in that as well. Chris Thomas, as you saw with Sergeant Williams and Mr. Howard demonstrating, oh my goodness, what's going on? Mr. Demons then made the decision at that point, he couldn't have a witness. So look at that. Those are all things in which you can get premeditation, how it was committed, the wounds that were inflicted, the back of the head. Going to Facebook. Showing again that the different information that you have before you belongs to this defendant. 772-713-9807. And that Melly Montana at iCloud.com is the email. Remember the Snapchat? Melly.Montana? These are names that the defendant uses over and over again to talk about and communicate and identify himself. And look, that phone says verified as belonging to Jamal Demons. Also remember Facebook. We have October 26th of 2018. Sun's going down. And the defendant's phone also shows him at this location in Cocoa. And he is dancing and singing and performing, wearing the same jacket, an identical jacket to what Chris Thomas was wearing the night before, and showing Mr. Henry wearing the denim jacket, like Mr. Williams was wearing the night before. And so the question was posed about a contractual agreement and losing money to be there. Well, ladies and gentlemen, look at the text messages between Mr. Demons and his mother, because he wasn't worried a couple of months before about missing a show because he was getting his hair braided and losing $1,000. But then this night, when his friends were killed, he's dancing and partying around and is worried about a contractual agreement. Just look at those types of information and those types of behavior and how someone is acting. Snapchat. If you recall, this is the argument between Mariah Hamilton and Jamel Demons, Melly Montana. Bored, coming everywhere with me, because if them crackers can grab him, it's my fault if you forgot. I keep Portland with, because at the end of the day, he did one of the realest shit in my life. Yeah, he covered up a murder. Did a very terrible job of it, but that's what he did. That's what this is referring to. This is less than 2 weeks after this homicide occurs, and that's what they're talking about. Ladies and gentlemen, you have a confession in this case. The defendant, and now look at the time. Remember we talked about the UTC? So subtract 4. So UTC 2,000 hours. You subtract 4, 1,600 hours. You do the conversion. So 4 p.m. 4 p.m. I did that with the smiley face. And that's what I said in opening. Context is key. All floor is coding. Awesome if you work at Google. Terrible at Broward General Hospital. Context is key. So you've learned Peasy Gambino, as you heard from Detective already, is potentially facing federal firearms charges, the gun dealer, is told by the defendant, I did that. Shh. And look at the messages between Mr. Demons and Mr. Gambino. Peasy Gambino is a blood gang member. He uses all those same information, slang words, changing of the letters that you learned about from Detective Polo. October 26th, he asks to reach out to see how the defendant's doing. And the defendant says, I did that. And to make a spelling, that, other times he uses DAT. And gentlemen, you saw the song where he has a song that he's released called THAT in his phone. So again, Instagram and how these all fit together. 6:58 a.m. Jamie King, RN, the defendant's mother. Are you here? I'm in Miami. I'm by the stadium. I'm a mess. I'm so worried. I'm here. Remember those CDRs where you kept sending her voicemail? Ladies and gentlemen, this shows that she's trying to contact her son. He is ignoring her, and so she's reaching out to her son, who responds back with, I love you, Mom. I'm good, Mom. Because he had the phone at that point. So the judge read you the law. Anthony Williams is dead, and it was premeditated. Ladies and gentlemen, evidence very clearly shows the defendant was caused by Jamel Dennis. Same as to Christopher Thomas. Talks about premeditation. Principles. So if, ladies and gentlemen, if you believe that Cortland Henry is charged, but that's for another jury on another day. If Cortland Henry assisted and helped and shot these two individuals to help out Mr. Demons, Mr. Demons is just as guilty. Because a principal is someone who decides to help before the murder is completed. And you have that with Mr. Henry, and making that drive and going out to the edge of the Everglades. You have that. He is a principal to first-degree murder. Mr. Demons is just as guilty, and so is Mr. Henry. So, in my few remaining moments, I want to briefly touch on the unlucky 13, because I'll give Mr. Adelstein, Mr. Henry. He's charged, right? So, from all those unlucky 13 people that are listed as suspects, they have one thing in common, and only one thing in common. They made a single online threat. In poor taste? Yes. Any other evidence that ties them to this case? None. No location data. No communication from anyone in that Jeep to say where they were. No DNA of any of those people on that Jeep. No ballistics evidence at their feet where they were sitting in that Jeep. No private confession. Because remember, all of these online threats, they're out there for the public because they're trying to get attention and trying to get some sort of benefit for that for themselves. Distasteful? Yes. A crime? No. There's no drop pins for an emergency pickup from any of those individuals. There's no phone for any of them at any of the scenes in this case. So, motive. We talked long and hard how we don't have to prove motive. Motive, it's intent. Intent is an action of the mind. So I'll give you motives. Anger, greed, resentment, advancement in the game. You heard $16 million was coming into Jameson Francois, and that you saw $15,000, $10,000 payments going to Mr. Demons. Simple math. Splitting something 4 ways or 2 ways with Mr. Henry, who wasn't smart enough to even properly give a statement to keep Mr. Demons away from the car. So we have all of these pieces of the puzzle that we have just talked about. And each and every one shows how this case has been brought together. Shows the physical evidence. And so, ladies and gentlemen, there's no murder weapon, right? The question that you have to answer, and that you can now answer based on all of this evidence, is that Jamel Demons was sitting in the back seat of that Jeep. And he was the one that fired the fatal shots that killed Christopher Thomas and Anthony Williams. And you know that because even if you choose to disbelieve one part of the evidence, 2 parts of the evidence, you can see what the overall picture is. The overall picture puts Mr. Demons in the backseat of that Jeep. It puts him holding a gun. You don't need a murder weapon to know that he committed these 2 crimes. Ladies and gentlemen, I would ask that you serve justice, that you deliberate, and that you return a verdict of guilty as charged as to murder in the 1st degree. Thank you.
All right, y'all. Don't be mad at me, but we've reached our natural stopping point. I don't want us to start the the defense's closing arguments, and then I have to go. Because I have to take my son to his doctor's appointment. So I'm actually gonna get ready for that, and then we will pick back up. Yeah. And we will pick back up. So I could actually do a later session tonight. Do y'all want to come back on later today, or do y'all want to finish up on tomorrow or Monday? I'm about to be snowed in. So what y'all want to do? Let me know, Taylor Gang. What y'all want to do? We can get back on later today. We can get on tomorrow, or we can just wait till Monday. What y'all want to do? D is voting to come back later today. Cindy is saying later today. Whatever I want to do, I have fun with y'all. Like, I want to make sure that y'all come back. So we're gonna do it. Okay, so we snowed in. So later today, we're gonna come back. I'm gonna come back after I finish my son's appointment. So it'll be later in the evening. So let's say around 5 Central. I'll be back around 5 Central, and we'll finish up. All right. So I mean, as long as y'all coming back, I don't want to watch it without y'all. So if y'all coming back, that's great. I'll get back on around 5 Central. And we'll finish up closing arguments. And then Malik, I'm going to try and find those other links for us so that we can start getting up to date on any of the other stuff. So I will see y'all in a little bit. We're gonna take a long break. Y'all clowning in the comments. I can't even keep a straight face. I will absolutely be careful. And I will see y'all later.